Corporations and another.
May it please the Board, I appear, together with my learned friend Mr. Simon Livingston, on behalf of the appellant, Mr. Gunesh, and my learned friend Mr. Gilbert Ithier, Senior Counsel, appears for the respondent.
Good. Thank you very much, Mr. Risugi.
My Lords, my Lady, as you know, this appeal concerns the dismissal of the appellant, Mr. Gunesh, who was head of stores for the respondent National Transport Corporation. The appellant had responded to the emphatic demands of the head of engineering of the respondent that he obtain important gearbox parts. The parts were for a fleet of 8 reportedly rickety Nissan buses with gearbox problems. The loss of those buses would have paralysed the south of Mauritius. Mr. Gunesh was sacked for obtaining 9 of the most important gearbox part, the main shaft, 8 and 1 spare. Had the anticipated breakdowns occurred, it may, in our submission, reasonably be observed that Mr. Gunesh could have anticipated disciplinary action had he not obtained the main shafts. How did it transpire that a decision so apparently unfair was justified, or found to be justified? Mr. Gunesh's answer in this appeal is threefold. First, the full burden of proof was not imposed on the respondent by the learned judge as it should have been, and the learned judge therefore failed properly to scrutinise the respondent's case. Secondly, the learned judge in our submission made fundamental mistakes in relation to the evidence. And thirdly, the respondent made an inaccurate and, in our submission, impermissible change in its case. It justified its dismissal to the court by reference to an alleged breach of procedure, a procedure in support of whose existence they could not produce a single scrap of paper. That, by way of preliminary, simply gives the overall flavour. The 3 points, however, follow the line of ground 1, grounds 5 and 6, and then what we come to really rather more in the application section of our submissions. My Lord, in our submission also, by way of brief preliminary comment, this appeal does give the Board the opportunity to correct a misapprehension as to where the burden of proof lies, which is in our submission apparent in the judgment of the Court. The appellant also recognises that to succeed here, to succeed in persuading the Lordships to do what we ask you to do, which is not to remit it, but to find that the respondent did not come up to the burden of proof, and to find that it didn't prove its case on misconduct, we must succeed on the facts.
Yeah.
And with the time allotted to me, I do propose, with the Board's approval, to concentrate on the factual submissions.
Right.
But turning briefly to ground 1, which is the burden of proof.
This is a new point, isn't it?
No, my lady, it isn't. The burden of proof isn't a new point, but what one of the sets of authorities I refer to are new.
But when you say full burden of proof, you mean the employee only has to show breach of contract and
Quite.
the employer has to show justification. But what is said by the respondent is that point wasn't argued below.
It was. What I think the respondent is saying is that the point on the civil code wasn't argued below. The new point in their submission, as I understand it, is that in relation to the citation of Article 1315 of the Civil Code. The cases in relation to the burden of proof in Mauritius, the Mauritian cases were referred to, and Phipson on evidence was referred to, and the appellant did submit that the burden lay for misconduct.
But the Phipson argument is the distinction between legal and evidential burdens.
My lady, yes.
That's different from the argument which you seek to raise as between employer and employee, which is specific to wrongful dismissal.
My lady, the appellant below did submit that the burden in respect of wrongful dismissal lay upon, the full burden lay upon the respondent.
So you say that the only new point is in relation to
the Civil Code.
The Civil Code. Do you accept that, Mr. Ithier? Do you accept that?
That point was not raised before
Yeah, the Civil Code point wasn't raised.
it was not raised.
No, I think Mr. Gill accepts that it wasn't raised. But he says that the argument was raised that the burden lay on the employer to justify it. Do you accept that?
Yes.
Yeah, right. Okay.
So it's just the Civil Code,
Right.
and I do require the Board's permission to refer to the Civil Code because objection has been taken to that. We've set out the other authorities, and in our submission, the position in Mauritius.
Well, we'll hear your argument, Gunesh.
I'm grateful, my Lord. It appears, other than on the Civil Code itself, that there is little dispute between the parties about the case law, certainly that in Mauritius. No comment has been made by the respondents in their written case about the Mauritian case law. So I will leave the Board with my written submissions in that regard.
Good.
And also with respect to FIPSN, with which the Board is well familiar.
Yes.
But I ought to take you briefly to the Mauritian authority. This is dealt with at paragraphs 19 to 21 of our written case, which is 903 to 904 of the bundle. We refer there to a translation of Article 1315 of the Civil Code, the first limb of which, and I will refer to the passages in the written case for this because the translation is there, the first limb of which is the party who claims performance of an obligation must prove it, and then the second limb, which is the important limb here, 904 of the bundle. On the other hand, he who claims to be exonerated must establish payment or verify the act which led to the extinction of his obligation.
I'm sorry, did you say 904?
902, I think you mean.
902 in the written, 904 of the electronic. Apologies, I gave the...
No, I beg your pardon, I think it's 902 of the electronic.
I seem to have a different number.
Anyway, what are you referring to? The Mauritian authority?
This is, I've started with Article 1315 of the Civil Code.
That is 19... I'm sorry, that is 902, yeah.
902.
Yes?
The second limb of which points out that he who claims to be exonerated, and in this case we submit that it was the employer who was claiming to be exonerated of its obligation to continue to employ the employee, must verify the act which led to the extinction of the obligation. In the employment context, though, this is explained in the textbook, the Mauritian textbook of Dr. Fock Khan, which we find at tab 1 of the authorities, or page 955 of the bundle. That's the primary volume of authorities.
Yes?
Translated in the third paragraph on page 957, according to Article 1315, paragraph 2, there's then an erroneous reference to the Code of Conduct, but if we miss that out, according to Article 1315, paragraph 2, it is the person who claims to be released from the performance of an obligation that must justify the fact that he's produced the loss of his obligation. If the employer wanted to avoid payment of the severance pay, it would be his job to establish the facts that ruled out this obligation, i.e. the serious misconduct or just cause for dismissal. The burden of establishing these facts rests with the employer.
Is that the legal burden or the evidential burden?
That is the full burden, and in our submission it's the full burden.
Well,
there is no distinction
what
made.
does the full burden mean? Does the full burden mean the legal burden?
The legal burden, forgive me, my Lord, yes, the legal burden. There is no
Well,
hint.
that's slightly incongruous position, is it not? The legal burden of establishing a case will normally rest on a claimant, or in old parlance, a plaintiff. I think the conventional wisdom is that the evidential burden of proving that grounds existed for the dismissal rests on the employer. But you say that that's not an evidential burden, that's a legal burden.
The legal burden, yes, to prove misconduct, to prove what that party is asserting as its defence.
Does that emerge from any of the cases?
My Lord, yes, I had better take the Board to the Mauritian authorities, which we deal with in our written case, paragraph 22, A to D. That's in the bundle at 902 to 903. And perhaps if we start with Pamplemousse, which is at 1186 of the secondary bundle of authorities.
Secondary bundle of authorities.
There are two, should be two volumes of authorities,
No, I
my
only
lady.
have one.
Oh, well, it may be that it was bound into one for you.
I think we only have it electronically.
Yeah, in any event, it's electronically, and my lady will be able to access it at 1186.
Thank you.
Yes?
Tab 24 in any event in the hard copy. This was a wrongful dismissal case. The appellant employer tried to argue that the magistrate was wrong to find that the employer had failed to discharge the burden of proof. The appeal was dismissed, and it was held in clear terms we would submit that the burden lay upon the employer to prove the misconduct. Page 1190 of the judgment. The learned magistrate of the industrial court found on the evidence adduced before him that the appellant employer had not discharged the burden that rested on it to prove that the termination of the employment was justified, and concluded that the summary dismissal of the respondent was not warranted. If one then moves to page 1193 and the antepenultimate paragraph of the judgment, as has been rightly pointed out by the learned magistrate in the present case, the burden is on the employer to prove that the termination of the worker's employment was justified. In so doing, it was incumbent on the appellant to prove on the balance of probability the misconduct of the respondent. So that
Well, I wonder whether nomenclature is all that important here. I mean, your essential point is that there is a burden, whether you describe it as evidential or legal, there is a burden on the employer to show that the dismissal was justified.
Absolutely.
Well, let's move on from that then.
I won't, as I say, take your lordships to Phipson, but the board to Phipson, but one aspect that does come out of the passages in Phipson that have been referred to in writing is the simple test, in terms of deciding on whom the burden lies, to strike out those aspects of the case which are under consideration. And if one struck out all the allegations of misconduct, plainly Mr. Gunesh would win. And Phipson suggests that that is one way of testing on whom the burden should lie. But yes, moving on, therefore, to briefly, before reaching the facts, to ground two, which is the question of the failure on the learned judge's part to admit or consider the transcripts of the evidence before the disciplinary committee which preceded the hearing before him.
Sorry, just before you go to that.
My lord, yes.
Where did the Court of Appeal fall into error in relation to ground one?
They held that only an evidential burden lay upon the respondent, and in our submission what that means is all the respondent has to do is raise some evidence of misconduct, and it leaves it for the employee on the balance of probabilities to prove that he was not guilty of misconduct. And that's why it matters. If it is as the Court of Appeal said, if the burden lies as the Court of Appeal said it did, and as they understood the learned judge to have held that it did, that is the effect. The employer simply has to produce some evidence, and the employee ultimately bears the burden of showing on the balance of probabilities that he wasn't guilty of misconduct. That, in our submission, is the wrong way round.
Yes. So nomenclature may be quite important after all. Yeah, so your essential point is that the court charged with the task of deciding whether the dismissal was justified has to apply a burden of proof to the employer to show
Yes.
that on the balance of probabilities, the case that it makes is correct?
Yes.
It's not sufficient to raise the issue and then transfer the burden to the employee?
Yes. And there's an example in the bundles, and again, for the sake of saving time, I won't take your lordships to it, but just for your note, there's an old case in the bundle from England called Lush and Russell from the 1860s, where the problem arose before the court, before Barham Park, that the pleadings had been a bit of a mess, to put it shortly, and it appeared from the way the pleadings had ended up that the burden was being put on the employee to show that he hadn't been guilty of misconduct. And the court in that very old, admittedly, case made the point that no matter what was said on the pleadings, the burden to show misconduct lay on the employer, not the employee. So it's not just Mauritius, it's in England as well, and the board has my written submissions in that regard.
Right, thank you.
So turning then to the question of, if I may briefly, the transcripts. We deal with the transcripts in two places. First of all, we say that the learned judge should have admitted and or considered them. And secondly, we say, if the board is prepared to hear our application in respect of looking at those transcripts and admit them, that they show an impermissible change in the employer's case before the judge in the Supreme Court. But taking the first point, which is simply the question of whether they should have been looked at by the judge. In our submission, it's plain that they should have been. The principle on which we rely is that derives from the case Northern Transport and Radakison, a Mauritian decision, 1975, Mauritius Reports 228. It's in the bundle, but I don't propose to take the board to it because the principle does not seem to be in doubt in this appeal. Right. And it is simply this, that the facts relied on by the parties before the court must be the same as those they relied on before the disciplinary committee. There is one exception, which is that an employee may rely on facts the employer ought to have known about, but it doesn't work vice versa. So what matters here is whether the employer changed his case. And in our submission, that needed to be examined, and as we will seek to submit later on, that he did.
But where do you get the onus on the court to look at these documents?
That takes us straight to the respondent's point, which is based on Bisondial, a Mauritian decision which they cite in their written case. And they make the point that surely it's up to someone to raise the question of some discrepancy between the two cases run. We accept in principle that the point must be raised in order to give rise to an onus on the court to look at the transcripts. However, in our submission, the point was sufficiently raised. It wasn't, we say, in Bisondial at all, but in this case it was. Our primary submission, however, before we reach that, is that it was for the respondent to put the transcripts in anyway because it bore the burden of proof to show misconduct and that there was sufficient material showing misconduct before the employer, i.e. at the time of the disciplinary committee. But coming on...
It's a bit of a tall order to say that in order to discharge its onus, however it's characterised, that you've got to put in the transcripts of the hearing before the disciplinary hearing, surely. I mean, that would not be conventionally done in this jurisdiction, would it?
As I understand it, the transcripts of the disciplinary committee are, as a matter of course, laid before the employment tribunal.
It's well outside my experience if that is so.
I'm assisted by my own friend Mr. Livingston in this regard.
What sort of proceedings are you talking about?
Before the employment tribunal, whether they're then needed in the EAT. And as I understand it, as a matter of course.
Do they constitute evidence then?
As I understand it, they do. If I may turn to my side,
Yes,
just
certainly.
to obtain...
Yeah.
I'm very grateful. They're produced in the bundle and cross-examination.
Well, there you get the notes of the members of the tribunal.
As I understand it, the transcripts.
Well, if there is one, but most employment tribunals, I'm sure, do not have running transcripts.
It's the notes of the disciplinary inquiry which are, as a matter of course, placed before the Employment Tribunal.
Well, are you meaning something other than its ruling? You mean
Yes.
the proceedings?
The proceedings.
Well, somebody must have asked for them, because that's a document within the possession of one of the parties.
In this case, it was a document produced by the respondent
Yes.
and then
Well,
distributed.
you could have asked for it.
Shall I take the board to...
Well, I'd just like an answer. You could have asked for it.
We did try and put it in
Before the trial judge?
before the trial judge. And I'll show you, effectively what happened is there was an attempt to put it in. The learned judge said, this can be used if you're making a point on inconsistency in cross-examination. This is the essence of what he said. And in any event, this court is interested in what is before it now. Let me take the board to that passage in the record.
You did have the opportunity then to
My Lord, we did.
cross-examine on the basis of the transcript.
We did, but
That seems to me to be the conventional way of proceeding.
in my submission, it isn't with the Northern Transport Principle, because that is about whether or not the case in the two places was inconsistent. One doesn't need to cross-examine in my submission about that, because the transcript is there. It's a matter for submissions. It either is or isn't different. And if it is different, under Northern Transport in my submission, as a matter of law, that new part of the case, simply is not permissible and cannot be considered by the judge.
Were you making a positive case that the respondent's case was different from the one put before the disciplinary tribunal?
It is not clearly delineated in that way in the submissions of the appellant, but it does appear to have been understood that way by the judge in the Court of Appeal. So may I must show the board the passage where there was an attempt to put the transcript in, I think, particularly given my lady's question, so that you can see exactly what happened. But this is at page 193. Forgive me, 191. 191. Really starting on 190. This is where Mr. Torbuth, for the appellant, seeks to put in the minutes of the 4th of November, the first of the sessions of the disciplinary committee. My learned friend Mr. Ithier said he wanted to, this is at the top of page 191, I must know the relevance and purpose of this exercise. What took place, I think that means to say, in respect of certain things before the committee. The court asks, this is the whole record of the proceedings? Mr. Torbuth of the sitting of, what are you producing? One hearing. You can't put evidence that was not adduced before this court unless there's some inconsistency or some other reason why it has to be produced. The court bases itself on the evidence that's before it now, if there's some reason you establish. And then Mr. Torbuth reserves his position until the arrival of Mr. Modi. And there is a short passage of cross-examination on this, on a very limited part of Mr. Modi's evidence. But our submission is that this wasn't simply a matter for cross-examination, this was a matter for submissions. And when one looks at the submissions that are made by Mr. Torbuth, and I'll simply give you the board the reference here, it's in the bundle at 290, lines 17 to 22. Mr. Torbuth submitted to the judge, we don't have what happened in the committee, and this will be on the point I will come. And the court later on page 289 at lines 1 to 20, encapsulated the submission for the appellant. Again, you would submit that it was incumbent before me that the defendant should have brought all this evidence. Mr. Torbuth responds at least to show that this was what took place in the committee.
I'm so sorry, I wonder whether the pagination is different. You say, starting at page 290, it's
Forgive me, 28, it could be 288. Our electronic bundles are 2 pages out, and so that may be why I'm...
What's the passage?
Yes, I see that.
So 288 is the first passage to which I referred.
Which line, please?
And then...
Which line?
Sorry, my lord, it's 17 to 22.
Right. Sorry, we don't have what happened.
in the committee, and this will be on the point I will come. We don't have what took place, and your lordship has to decide the issue of unjustified dismissal, etc. And then over the page at 289, at line 11, no, again you would submit that it was incumbent before me that the defendant should have brought all this evidence, Mr. Talbot, at least to show what it was that took place in the committee. And then the court, in answering the submissions, the learned judge, and this is at 332, at 11 to 15, it has been amply established by the testimony of witnesses Malam, Hassam and Modi, the disciplinary committee was at all times of the disciplinary hearing in presence of all the material facts and circumstances. So in our submission, the learned judge felt that the point had been taken, and his answer to it was the case was consistent in both places. And our submission, reduced to absolute simplicity, is that he could not possibly decide that without looking at the transcripts.
Right.
Likewise, in the Court of Appeal, the submission for the respondent was that his case was the same in both places. He didn't submit the point had not been taken. He submitted the case was the same without producing the transcripts, and the Court of Appeal agreed without seeing the transcripts. So that is why we say the transcripts should have gone in.
Right.
My Lord, coming now to the facts, which is where I need to be. Forgive me for taking a little while to get there.
That's all right.
In short, this has to amount to, and does amount to, a submission that the learned judge's conclusions were perverse. Otherwise, we cannot overcome the hurdle of Devi and Roy, which I hope we've dealt with sufficiently in writing. And there doesn't seem to be any dispute from a learned friend about the principles that apply or the exceptions.
Well, they're very, very well established.
They're well known. The only point on which I do need your permission in respect of law to refer to is that in respect of delay. My Lords and my Lady know that we have not pursued a constitutional ground of appeal for delay. However, what we do seek to do is to persuade you to take into account the substantial delay in the delivery of judgment of some 18 months in considering whether this case passes the Devi and Roy test. It's in that context that we rely on delay. My learned friend objects, therefore I must seek the board's permission to put that point before you. May I take it you'll hear it de bene esse again?
De bene esse again.
Thank you very much. Simply put, we say that that is really a matter of law as to whether it is appropriate to take into account delay in this context, and therefore it is appropriate to allow it to be the point to be taken now, and we refer the board, and I won't take you to it because it'll be a case familiar to you, but Jarvis and Skinner is an example of a case in which delay was applied in the way we submit it should be applied in this case. So coming now to the points on the facts that we make, and my Lords and my Lady, may I take you first, just as a reminder of the basic chronological framework to our chronology, which, and in particular, pages 888 of, I hope this will be correct this time, 888 of the bundle, and may I start at the top of that page, or not quite the top, but on the 6th of January, that's the date where the head of engineering, Mr. Raj Kumar, makes the point about the 8 noisy gearbox buses at the Suyak depot, and asks that spare parts for gearboxes be procured.
Now, Mr. Raj Kumar was the head of engineering.
Head of the engineering department at the relevant time, although he then went on sabbatical for 2 years. On the 14th of January, the appellant launches the immediate quotation procedure to obtain spare parts for Nissan buses, including these main shafts. Moving to the bottom of the page, so that's stage 1 of the process, the launch of the procedure. Stage 2 is when the bids put in under this immediate quotation procedure are considered by the Management Tender Opening Committee on the 21st of January, and this is the start of stage 2, which is the consideration of the bids. And over the page, to the 9th of February, we have the Management Tender Quotation Committee considering the quotations. Then at stage 3, on the 23rd of February, orders are made. And those orders at stage 3 have to be approved by a technical mechanical officer, and they are. The first set of orders are the 23rd of February, and then if we go to page 891, on the 2nd of April, the last of the relevant orders for 5 main shafts is made. So those are the 3 stages and the principal events in those 3 stages. Going on at the same time is a live tender or an existing contract with Mr. Casamali on which my learned friend for the respondent relies and on which the learned judge placed emphasis. That we see on the bottom of page 888. On the 26th of January, that contract was entered into. There is an attempt to obtain main shafts from Casamali on the 4th of February. This is on page 889. But it's apparent that Casamali are unable to deliver at the time of the 9th of February consideration by the MTQC, and the first main shaft that Casamali can deliver doesn't come until the 6th of May 2004. That's over on page 891. So that gives the broad chronology. We also say, when dealing with the facts, that the way in which the learned judge dealt with them demonstrates the, as we submit, erroneous, or the misapplication of the burden of proof in this case. So, to take the first 2 points and dealing with these in short form at this stage, the first point is that Mr. Raj Kumar's evidence, that of the head of engineering, though entirely accepted by the learned judge, was totally disregarded. And in saying that, we also submit that what the learned judge in respect to the burden of proof failed to do is to consider whether the National Transport Corporation had any answer to Mr. Raj Kumar, which they plainly in our submission did not. So that's an illustration of how the burden of proof was misapplied and the effect of its misapplication in this case. Our second point relates to Mr. Modi, the auditor's evidence about the restriction of the use of the immediate quotation procedure to off-road buses, buses which had already broken down.
Mr. Modi was the internal...
The internal auditor, my lord, yes. Buses that had already broken down. And we say there that what the judge failed to do in respect to the burden of proof is to look to see whether, in fact, the respondent had actually supported the evidence of Mr. Modi. And if he had looked, he'd have found there wasn't a single scrap of paper and that Mr. Modi's evidence was entirely unsupported in respect of this alleged restriction on the use of the immediate quotation procedure. The importance of that restriction is that if it were the case that a bus had to be off-road, it's common ground that on the 6th of January there were no buses off-road. What Mr. Gunesh relied on was the request from the head of engineering department, which we'll look at in a moment, and indeed it may be a convenient moment to look at it right now. This is what's been called document P, and this is the document dated the 6th of January, which records the head of engineering's request. It's at 385 and 386 of the bundle. And on the first page, it deals with the buses that are off-road at that time, and there are some from Suyak, which appear to be off-road in the middle of the page, that is Suyak Depot, but for problems other than gearbox-related problems at that stage. But if we then go over the page, the document deals with buses which are not off-road, and we know that because there's no bus number recorded in the list. And what we have below in the handwritten notes are Mr. Gunesh's notes of his meeting with the head of engineering. It's note 6, which is, for want of a better word, translated in the Statement of Facts and Issues at paragraph 6. That's page 877 of the bundle, but I'll read it, if I may, to the board now. Note 6, report from SOD, that's the Suyak Depot. More than 8 gearboxes Nissan are running with noisy sound to ensure the availability of all the important items. That's signed by Mr. Gunesh on the 6th of January. And it's common ground that the main shaft is the most important gearbox item. You'll find that, my lord, in the Statement of Facts and Issues at 6b, page 877 of the bundle.
This is Mr. Gunesh.
This is Mr. Gunesh recording
what he was told.
What he was told.
By
says
Mr.
at one
Raj
stage,
Kumar.
exactly. He says at one stage in the evidence, he speaks, I write. So, dictated. We'll look at what Mr. Raj Kumar says about it in a moment. But first, I think I must take the board to the passages in the judgment about which we complain in this regard, so that I can show you that and then show you why we complain about them. So page, if I may, of the judgment 328. Starting at line 6, the plaintiff is materially given the lie on this issue by document P and witness Raj Kumar. That we submit is a complete contradiction when the learned judge says later on that he has absolutely no difficulty in accepting as true and wholly reliable the testimony of Mr. Raj Kumar. But coming on to the specifics, I should at this stage point out that the specifics on Mr. Raj Kumar's evidence are set out in our written case at pages 918 and 918 to 919 of the bundle, subparagraphs A to F, but I'll refer to them as we go through. The next passage in the judgment reads, it contains, this is document P, neither any approval to the plaintiff nor any request to him for the purchase of 9 main shafts. That's the point about document P showing no evidence of a request, of the necessary request. Down to line 14, there is neither any approval by the committee nor by Mr. Raj Kumar, the head of engineering, nor any other request made to the plaintiff as head of stores to proceed with the purchase of 9 or any number of main shafts. Then down to line 34. Document P, on which the plaintiff sought reliance, does not support his version. The written notes emanate from the plaintiff himself. No recognition of the dictation aspect there. And over the page to 329, starting at line 18, summarising in the judge's view that the evidence of Mr. Raj Kumar, there was no specific need which arose at its meeting of 6th of January for the committee to identify these gearboxes or any main shafts were urgently needed. The gist of his evidence was the committee was only responsible to identify parts urgently needed for buses off-road. I've paraphrased a little there. So if we now look at why Mr. Raj Kumar's evidence and why we say that it was wholly contrary to those passages in the judgment to which I've taken the board. Mr. Raj Kumar's evidence starts on page 533, 534, forgive me, of the bundle, but if I can take you straight, please, to 536. And this is where Mr. Raj Kumar is shown document P. Have a look at the date, dated 6th of January. He identifies the handwritten remarks as the handwriting of Mr. Gunesh. Do you remember that this is how it happened? Yes, I remember. We discussed. He said a problem with gearbox noisy. How many buses involved? 7 to 8. Running at Suyak, which had noisy gearboxes. Action needs to be taken. That's why you put the observation, do the needful. That was actually on the first page of document P. Yes, do the needful relates to this side, and on the verso, the second page, it's items which we discussed and which Mr. Gunesh noted. Therefore, you confirm the existence of that meeting between you and Mr. Gunesh. The existence of that meeting, yes. What, and the court asked the critical question, what that committee had decided concerning these shafts, those shafts. No, at committee level, my lord, what we said was we told Mr. Gunesh we have 7 to 8 buses running with noisy gearboxes. Action must be taken. Take action, what does this mean? Take action, he must effect his procurement. Procurement for gearbox parts, spare box parts for gearboxes. That, in our submission, is as clear as it could be. Over the page, to page 538, Mr. Raj Kumar points out between lines 30 and 40 that he doesn't deal with immediate quotation procedure. That'll be important in a part of the submissions we come to in a little while. But on this particular aspect of the submissions, page 539, on whether a specific instruction to buy should have come from the head of engineering, no, is the answer. And the court says, no, you do not give instructions to buy. This is line 18. No, it was not your duty. No, it was not my duty. My duty was the responsibility to tell what problems there were, and what the buses were that weren't running. So, clear division of responsibilities here. The head of engineering points out what's needed, and it's for the head of stores to go off and look at whether he's got those parts, and if he hasn't, decide how to get them.
Yes.
And then over the page, there is a useful illustration of the dual purpose of document P. I'll paraphrase this passage of the questioning and the evidence, but in short, what Mr. Rajkumar is dealing with is that an endorsement, please do the needful, is required in respect of buses which are off-road, but then at line 19, he says, after that, we enter into discussions, we discuss about problems the depots are facing, and as Malone from Mr. Ithier accepts there, that's another thing. And that is the other thing to which the notes in our submission, the notes on the second page of document P refer. But to round it off, in re-examination, Mr. Rajkumar on page 542 makes it absolutely clear what he expected the effect of document P to be. And starting at line 34, why the depot brought to your attention, and you brought to the attention of the committee, that there were 8 buses which were running with noise in the gearbox. What was the aim? Was it to warn? To warn, to do the needful, to be able to effect purchases, to avoid, if ever there would be a breakdown, to be prepared. The corporation had float units. Therefore, when we receive the spare parts, we prepare the float units, running forward a little. Therefore, instead of a bus waiting for a week to get repaired, with that float unit, the bus on the same day can be on the road. So it's anticipatory. He's not waiting for buses to be off the road. He wants to anticipate and have everything ready in advance, which is just what Mr. Gunesh did.
That's in connection with document P, is it?
That is all in connection with the meaning and effect of document P, my lord. Yes. I won't go back to those passages in the judgment that I took you to, but in our submission, those passages which I showed the board cannot stand in light of the evidence of Mr. Rajkumar.
And the procedure after the head of stores has seen whether or not the items already in the store is what for these urgent items? In outline.
He has a look, and if he decides that they're required, he launches the immediate quotation procedure, and then we get into stages 2. That's stage 1. Stage 2 is the consideration by the Management Tender Quotation Committee, and stage 3 is the making of the purchase orders, which at that stage do have to be signed off by the technical mechanical officer. But it's at that stage that engineering gives its imprimatur to the orders themselves.
Who does that?
The technical mechanical officer, there were 2, Mr. Gujador and I believe another, but this is dealt with in the statement of facts and issues, and I think also in the chronology. There are references to the relevant pages there.
But Mr. Rajkumar is not in any way concerned with immediate quotation procedure.
No, my lady.
So if that choice lay solely with the...
With Mr. Gunesh.
It is.
What
he said in relation to that.
And what Mr. Gunesh relies on is a request. That is what he says he needed from the head of engineering.
He had to decide what he had to tell the committee when he made that request.
No, he doesn't have to tell the committee anything to launch the request. He launches the immediate quotation procedure, and then when the bids come in, the committee then looks at those bids and opens them. But he's the one who decides whether to launch the immediate quotation procedure or not. And what he needs for that, his case is and was, what he needs for that is a request from engineering. He doesn't need, you may order X number of main shafts, and he doesn't need a tick in the box from the head of engineering to say you may use the immediate quotation
But he
procedure.
has to exercise his judgment on the question whether or not there should be a use of the immediate quotation procedure, knowing that there was another contract outstanding for the delivery of main shafts.
Quite so, although he didn't know that until the 26th of January, so the criticism will come to this point, but the criticism that is made of his launch of the procedure on the 14th of January, and the judge says he did it when he was fully aware of the live tender. Well, he wasn't, because the live tender didn't take place till the 26th of January. Or that contract wasn't signed until the 26th of January.
Yes, but it doesn't follow that he didn't know about that upcoming transaction.
The evidence was, and the agreed position on the statements of facts, is that he knew about it on the 26th of January. I think the judge deals with that, actually.
Well, he said he knew about it.
On the 26th of January. I think it's...
Can we just have that?
Of course,
because it's
yes.
quite a limited finding the judge makes.
26th. Yes, this is page 326 at 1. It's not in dispute that following the normal tender procedure, a contract had already been awarded to Casamali, etc., signed on the 26th. Then going down to 4, the tender awarded to Casamali was expressly brought to the attention of the plaintiff in his capacity as head of stores on the 26th of January.
Yes, that's saying it was then brought to his attention on that date. It doesn't say he'd had no knowledge of it before that date.
My lady, no, but that... I don't believe there is any evidence that he had any knowledge of it before then, and it's certainly been the agreed position in the chronology and statement of facts and issues that that was the date on which he had knowledge of that contract.
So you're saying that it was only that was when he acquired any knowledge of this tender?
That appears to be the case on the evidence, yes.
Well, certainly there's no finding that he had prior knowledge of it. And you say that that is fundamental to any criticism of him in relation to this?
Had the learned judge to be entitled to make the criticism that on the 14th of January he was fully aware of the contract, the learned judge would have had to qualify what's said at number 4.
Yes, but the contract is not awarded pursuant to the immediate quotation until a date in February, is it?
My lady's right. So there's a second stage. I've dealt with the 14th of January. He could have then aborted. But we'll come to this. The reason he didn't is because Mr. Casamali, as I pointed out when we were going through the chronology, couldn't produce any main shafts.
Yes, but the issue we're dealing with is whether he should have disclosed that to the people making the decision.
That was charge 1, and the answer on that, my lady, is that Mr. Ramjerton, the financial officer who signed the Casamali contract on the 26th of January, was on the committee on the 9th of February. So the appellant didn't need to tell anybody. They knew perfectly well. Mr. Ramjerton had signed the contract a matter of days before.
Right, let's move on, because we don't have very much
my lord,
time.
yes, forgive me. So, coming now to the second point, which is Mr. Modi and his evidence about the...
What was his position?
He said that the immediate quotation procedure...
What was his...
forgive me, he was the internal auditor, my lord. His evidence before the judge was that the immediate quotation procedure could not be used for anything other than off-road buses. And in our submission, that was wholly unsupported. If we look to make that good, no witness produced a written procedure which said that. The written procedure to which Mr. Modi referred is the one that appears in the Statement of Facts and Issues, cited at paragraph 8 of the Statement of Facts and Issues, page 878, NTC E9 1995, which simply says it's for the procurement of spares and supplies of immediate needs and for short-term stockings. I probably don't have time to take the board to the cross-examination now, in which he was asked where the sectional procedure was, but it's page 205, lines 19 to 36 for the note, and we deal with this in our written submissions. It suggested that Mr. Bagaruti supported Mr. Modi in this regard, but again, Mr. Bagaruti's evidence is paraphrased in paragraph 8 of the Statement of Facts and Issues. He said that you could use the immediate quotation procedure where another supplier under a live tender couldn't give you the part. Not, therefore, restricted to off-road buses.
I'm sorry, what was the position of Mr. Bagaruti?
Bagaruti said you could use Mr.
No,
Bagaruti.
but what is his official status within the organisation?
I'm so sorry, my lady. He was the acting chief mechanical officer, but I'll confirm that in a moment.
Thank you.
In fact, while I'm assistant, forgive me, my lady, assistant store manager.
Thank you.
We then come to the third of our points, which is that the learned judge, in criticising Mr. Gunesh's evidence in cross-examination, and again I need permission, but I'll take it I have it to make this point briefly, criticised Mr. Gunesh's answers in cross-examination, suggesting that he'd changed his case, that he'd first denied that he needed approval from the head of engineering for the first stage of the process, but then accepted that he did. In our submission, the learned judge here simply confused stages 1 and 3 of the process. the appellant was consistent throughout that the engineering department did not have to give approval to the use of the immediate quotation procedure, that he had nothing to do with that, and I've shown you the passage in Mr. Rajkumar's evidence about that. If I can simply give you the references to Mr. Gunesh's evidence about this, they're at 506 lines 26 to 29, 507 lines 12 to 16, 508, 24 to 27, and 512 to 513, that's lines 30 to 2, 518, 40 to 44. But we submit that Mr. Gunesh was entirely consistent throughout in denying that he required approval for the use of the IQ procedure from the engineering department, but accepted always that he did require what he had, which was the technical mechanical officer's sign-off at the end. That brings me to the fourth point, which is subheading D in our written case, to orientators 75 to 76 of the written case, 924 to 926 of the bundle. This is the criticism that we've touched upon with my lady's questions in relation to the use of the immediate quotation procedure in light of the existence of the Casamali contract, and I've dealt with that really already in my submissions, the first stage, the 14th of January stage. As to the 26th of January, after the Casamali contract came into existence and persisting in the procedure, we make 2 points. Firstly, Mr. Rajkumar's instruction was not rescinded. Secondly, Mr. Casamali couldn't supply any main shafts till May. And there was evidence that Mr. Gunesh knew about this. And we've seen what Mr. Bagaruti said about the inability of a live tender supplier to be a valid reason for launching the immediate quotation procedure. And here, my Lord, I hope to show the board in action, as it were, how the learned judge's approach to the appellant's case, in light of what we said about the burden of proof, was erroneous. Looking at the way he dealt with the submissions that were made about the Casamali delay or inability to supply main shafts, it's clear in the passages I'm about to show you that he looked at what the appellant could prove, not what the respondent could prove, and was also reluctant to accept what is now an agreed position, which is that Casamali couldn't supply the main shafts. So if we start on page, if we may, at 294 of the bundle, here Mr. Torbuth is making these submissions about Casamali, and he starts with the Casamali delivery schedule and says it's not disputed that Casamali could not satisfy, and I'm going to paraphrase a bit in order that we can go speedily, and the court then refers to evidence of Mr. Modi. Forgive me, my Lord, I do need to show you 2 documents before we plunge into this, I'm so sorry. A document at page 382, which is the bin card.
282 or 3?
382, my Lord.
382, thank you. Bin card.
Starting at 382, but actually what we need to look at is 383 and 384. This is the record of main shafts in stores, the bin card for main shafts, and one can see clearly from 383 that the name of the supplier is in received from or issued to the central column. Casamali doesn't appear in the whole of the first part of 2004, and if we go over the page, we see the first notation for Casamali on the 6th of May 2004, which is consistent with the... So that's consistent with what I've shown you in the chronology. That's document N, the bin card. Document C was the appellant's response to the internal auditor, Mr. Modi's report. And if I take you to 343, and what he says at the bottom of that page, main shaft received from Casamali as per tender 316 only on the 6th of May 2004, purchase order issued on 4th of February. We were always in contact with the supplier, and when purchases were made in April 2004, that was the last of the purchases we looked at earlier in the chronology, the supplier concerned his parts were still in Japan. So turning back to the way this was dealt with, when submissions were made on this, and the learned judge's approach to this, back to where we were on 294, having referred to the schedule, Mr. Torbuth having referred to the schedule of delivery of Casamali, the judge then says, referring to the evidence of Mr. Modi, where does he say there was no supply from Casamali? And I'll simply give you the board the note for this. Mr. Modi at both page 212, 1 to 3, and 200, at the top of 200, at lines 1 and 2, both confirms the 6th of May date for the Casamali main shaft and the inability to supply on the date of the MTQC meeting, the 9th of February. But so the court says, where does he say there was no supply from Mr. Casamali? Where does he say he was unable to do so? Further down that page, lines 19 to 20, Mr. Talbot rightly refers the court to the evidence of Mr. Modi, which, as I've said, is at page 200 of the bundle, lines 1 to 2. Over the page, the court at line 10, I don't know whether you're submitting from that. It must have meant this was the first one they received, but he never himself used the term first one. The court seems to be making the point that where's the evidence that this was the first Casamali delivery? Well, naturally, Mr. Talbot takes the court to document N, the bin card. That we find him going to document N at the bottom of 296. He goes to the bin card, and the court's reaction to the bin card is at 31 to 32 on 297. As I've said, this document does not say it was the first time it was delivered by Casamali. Well, on the face of it, it did say exactly that. One could see that that was the first delivery from Casamali from the bin card. Over the page, further from the court, lines 9 to 11 on page 298, this is it. Each time you say something, it must be supported by evidence. Where does it say by Mr. Modi that this is the only document? Now the court is questioning whether there might be some other document other than the bin card. Over the page to page 299, line 26, line 25, you're referring me to documents which do not support. Now, your whole line of submission was that because Casamali had failed to respect the schedule, that's why the IQ was released. This is not the case. Well, it did appear to be the case from document N, the bin card. Over the page, Casamali was not, this is lines 23 to 25, Casamali was not called as a witness, so we don't know, the court says. Page 301, Mr. Talbot now tries to refer to document C, Mr. Gunesh's explanation, and that evidence about his contact with the supplier. And the court says at the bottom of the page, this does not answer my question, does not support your argument. The date of the immediate quotation was the 14th of January. Here we're speaking of April and the 4th of February. And that was the very period in which the purchases were being pursued. Over the page, where is it in the evidence from the plaintiff that at the time he was preparing the immediate quotation, he was informed by Mr. Casamali that he would not be able to supply? We would say it was in document C, the response. Over the page to page 303, Mr. Talbot, the court again asking at line 19, where is the evidence? The evidence is there was no supply from Casamali during that period, which was plainly correct, Mr. Talbot's submission there. Over the page to 304, yes, but where is the communication? Where is the evidence? What the court seems to be questioning is, where's the evidence from Mr. Gunesh, or where's some other evidence before him of the communication with the supplier? I don't have it, my lord. This is it. You don't have it. You don't have it.
Well, I'm afraid your time is up, Mr. Gill. So if you'd like to wind up, please.
So, my lord, that deals with the principal points on the facts. The remainder of them can be dealt with in my submission. Forgive me, I'd refer the ball to my written submissions.
Yeah.
As far as the transcripts are concerned, I had intended to show my lords and my lady, those passages in which it's plain in the transcripts that the immediate quotation procedure was not said before the disciplinary committee to be or to depend upon the existence of the off-road buses. The position was put much more broadly than that. The references in the transcript, perhaps, well, they're dealt with in our written case in any event, but to highlight 703, 705, 784, 787, and that's the evidence of both Mr. Modi, Mr. Gaia, and Mr. Ramjetan, all of whom, to give the example of Mr. Gaia, immediate quotation means for me items we badly need and which are not present in stores. That gives a flavour. A very similar submission was made, and this I may just have time to show the board on page 849 of the bundle. This was the submission made by Mr. Collandi for the respondent to the disciplinary committee. In the first passage of his submissions at the end of the disciplinary committee hearings on the 23rd of November, immediate quotations is normally used according to the evidence of the management, firstly when there's an immediate need, an urgent request, and also when there's a normal quotation ongoing in relation to matters that is being required. That appears to be a reference to Mr. Bagaruti's.
Sorry, the page is 809, is it?
That should be 849.
Thank you.
849.
Yeah.
One can also see from the transcripts that at that stage it appears the respondent's case, and this one can see from 850 and 851, the respondent's case appears to have been to challenge the authenticity of document P. So we have passages on 850 in which Mr. Collandi refers to them being photocopies, and various criticisms are made of the authenticity of document P, and we have more of that on page 851. Of course, having had the evidence of Mr. Raj Kumar, it was no longer possible to criticise the authenticity of document P. And what eventually came from Mr. Modi about the restriction of the immediate quotation procedure to off-road buses rather plugged that gap.
Right.
My Lord, unless there's any specific matter with which I can help the board now, that is the appeal.
Thank you very much. Mr. Livingston? Yeah. Mr. Ifia?
Yes. Thank you, Lord. On the burden of proof, we fully endorse the pronouncement of the Court of Civil Appeal, which is to the following effect. Once the plaintiff, the appellant now, had established the existence of a contract and breach of it by the defendant, the evidential burden of proof shifted to the defendant, to the employer, whose duty was not only to disprove the facts alleged by the plaintiff, but also to prove that the charges against the worker had been proved. Once the respondent had attempted to do so by calling his witnesses, then it was up to the judge on the whole of the evidence to decide whether the plaintiff had established his case on a balance of probabilities. It was for the plaintiff to establish, to satisfy the legal burden of proof, namely that the termination of his contract was unlawful. So the plaintiff, the appellant, bore the legal and evidential burden, but this evidential burden shifted to the employer in the course of the trial, and the employer had to prove that the charges had been proved against the worker. This was...
So you accept that the employer had to establish that on the balance of probabilities?
Yes. And the judge, the trial judge, was fully alive to this principle because at page 332 of the record,
Yes.
he said this: "It is abundantly plain, therefore, that the evidence overwhelmingly established the charges of gross misconduct in respect of the plaintiff, which would justify the termination of his employment by defendant number one." So that is the finding of the judge with regard to the burden which the respondent bore, and he was fully satisfied that this burden had been proved and satisfied.
So it's not a case, as Mr. Risso-Gill would have it, of the employer raising the issue and the burden then transferring back to the claimant to show that the case made by the employer should be rejected on the balance of probabilities. You accept that it's for the employer to establish what it claims is the justification for the dismissal on the balance of probabilities.
That is the evidential burden of the employer, yes.
Yes.
Having done so, it remains the duty of the judge to determine whether the breach of contract, as alleged by the plaintiff, was unlawful or not. And this is why at the end, at the penultimate paragraph of his judgment, at page 335, he concludes that the plaintiff had failed to prove on a balance of probabilities that his employment had been wrongfully terminated by the defendant number one.
Yes.
This is in line with what Phipson says at page 964. Paragraph 606. So far as the persuasive burden is concerned, the burden of proof lies upon the party who substantially asserts the affirmative of the issue. If, when all the evidence is adduced by all parties, the party who has this burden has not discharged it, the decision must be against him. It is an ancient rule founded on considerations of good sense and should not be departed from without strong reasons.
Yes.
That is the respondent's point with regard to the burden of proof.
Yes.
Yeah, I'll deal now with the transcript. Now, with regard to the transcript, the approach taken by the Mauritian courts is different from that taken here in England. English tribunals or courts review the decision of the committee and decide whether the decision of the committee was reasonable or not. But this is not the approach taken by the Mauritian courts. Mauritian courts substitute its own decisions and on the basis of the evidence which is adduced before it. So the adduction of such evidence will determine the outcome of the trial. If the approach of the Mauritian courts were similar to that which prevails here, then of course the transcript of the proceedings before the committee would have some relevance in order to determine, of course, whether the committee reached a reasonable conclusion. But this is not the case in Mauritius. The Mauritian court will decide upon its own, and that being so, the transcript of the proceedings is both irrelevant and inadmissible. It is irrelevant because the court must decide on the basis of the evidence which is adduced before it and on no other evidence.
But surely, if evidence contrary to that given by, for instance, the employer, has been given before the disciplinary committee, it's open to the claimant to refer to that in cross-examination.
Absolutely. This is the exception, yes. I'm coming to that because I was going to say that it is not permissible without the leave of the court, and it is for the workers' council to establish the basis for the admissibility of that document. And it should have done so in this case by trying to prove that what Mr. Moody or the witnesses of the employer had said in court was different from what they had said before the committee. But this exercise was not conducted in any way at all by the appellant's then counsel. That being so, there was no reason for the trial court to admit the transcript of the proceedings. And this is reflected, this principle is reflected in the judgment of the Supreme Court of Mauritius in Bissundial and National Transport Corporation, page 1043.
Could you give us the bundle reference? Delay A. No.
1043, my lord.
Thank you.
1043. It's 1043. And at page 1044, at the bottom of the page, there is the following pronouncement. It is therefore not the duty of the court to conduct some sort of review of the findings of the disciplinary committee. The evidence of a disciplinary committee at the trial before the industrial court is merely meant to show that the employer has given to the employee an opportunity to answer the complaint against him before making his decision to dismiss him. This being so, unless it is in the contention of either party that the charges or facts put before the committee were in a material particular different from those brought before the court to determine whether or not the dismissal was warranted, there is no necessity for the whole record of the proceedings before the committee to be put in. And we submit that this is a correct appreciation of the rule which prevails in Mauritius, given the approach of the Mauritian courts to determine such cases. And as I said, as I alluded to just earlier, it was never the case for the appellant that the respondent was relying before the court upon charges or facts which differed from those before the committee, or that the respondent's witnesses had contradicted their version before the committee.
Yes?
That is my point with regard to the transcript. My learned friend has not addressed the board with regard to the right of the court to substitute itself, substitute its decision for that of the committee. And so I will rely upon my statement of case, paragraphs 12 and 13, if any need arises for that. Now, the next point is whether there was new evidence or different evidence upon which the trial judge relied, and whether he was entitled to do so. The only additional witness who was called before the court and who had not given evidence before the committee was Mr. Bagirati. In fact, there was also Mr. Malamasam, but Mr. Malamasam had been called to rebut an allegation made by the appellant in the course of the trial with regard to the composition of the disciplinary committee. Mr. Malamasam did not depose as to the facts of the case. So the only additional witness was Mr. Bagirati with regard to the facts of the case. Well, was he entitled to do so? Well, the correct principle in this respect was stated by the board in SMEG Limited and Per Sad, 2012, UKPC 23. And at page 1000, we can see the principle which Lord Dyson laid down. Page 1000.
Yes?
Yes, no, this is at page 1010, actually. He said this: in the argument before the board, much was said by counsel for SMEG of the fact that Mr. Pears had called witnesses who had not given evidence before the committee, notably Mr. Kurup Das and Raj Kumar Singh. It is true that the magistrate was impressed by the evidence of these witnesses and relied on it as corroborating the account given by Mr. Persad. But the board does not consider that this means that there was an infringement of the Northern Transport Principle. First, the principle should not be extended to preclude a worker from relying in court on fresh evidence which does no more than support the case which he has always run. What applies to the worker would apply to the employer in such a case, of course. So this is a principle, and it has been recognized as being correct, and the evidence of Mr. Bhagirathi has therefore been correctly accepted by the courts, because Mr. Bhagirathi did not give a different version from that of Mr. Modi, nor did he contradict Mr. Modi, or did he support charges which had not been laid before the worker, before the committee. In fact, Mr. Bhagirathi's testimony is to be found at page 234. And Mr. Bhagirathi, to summarize his testimony, has confirmed Mr. Modi's version on three main aspects. Firstly, he stated that the IQ procedure was used only for buses which were broken down. This is at page 234. Secondly, he stated that the head of engineering department must give his initial authorization before the IQ procedure could be launched. This is page 235. So he confirmed that it is not in the discretion of the appellant, it was not in the discretion of the appellant to issue and to launch such a procedure without a formal request from the head of engineering department. And this is what Mr. Modi said as well. And this is accepted by the appellant. And thirdly, Mr. Bhagirathi confirmed that in document P, on the recto signed by Mr. Rajkumar, there exists no reference to the purchase of main shafts, to 9 main shafts.
I'm so sorry, would you just repeat that point?
The third one is that he confirmed, Mr. Bhagirathi confirmed that in document P, which has been referred to already,
yes,
on the recto, on the first page, which was signed personally
yes,
by Mr. Rajkumar,
that's right,
there exists no reference to the purchase of 9 main shafts as alleged by the appellant. And this is clear from the document. So, the evidence of Mr. Bhagirathi, my point there on that particular issue was that the evidence of Mr. Bhagirathi fully supported that of Mr. Modi, never contradicted it, and therefore was fully admissible by the court.
So Mr. Gunesh did not have the authority on his own initiative to order the 9 shafts?
Absolutely not. And he acknowledged it, he conceded it on 3
occasions. Is that the burden of the complaint against him, that he ordered these 9 shafts without authorization?
Yes, he did so without authorization. He should have obtained, first of all, the permission or request.
Well, on one view, it seems a slightly harsh penalty after 20 years of service, 20 plus years of service, for him to be dismissed for ordering shafts without authorization. Is there something more to the complaint than that?
Well, there were 4 charges.
Yes.
And all of them were found to be proved by the court.
Yes, but the burden of the complaint against him was the ordering of these shafts.
The main charge was the purchase of the shafts. Yes.
Yeah, very well.
And as I said, the appellant fully conceded that he had no right to proceed with such a procedure without the prior authorization of the engineering department. And this concession has been made 3 times, as I said, at pages 491, 507, and 510. 510, for example.
Yes.
Says, he is the assistant engineer, so we're speaking of the senior mechanical officer. Is he who prepares the list for spare parts needed? Yes. We're finding where it begins, procedure. It's the senior mechanical technical officer who prepares the list of spare parts needed. He sends them to the head of engineering. Witness, this is the appellant. Yes. Head of engineering, then what does he do? He approves. Head of engineering discusses with them, then he puts in a report. Store superintendent, please do needful. This is what is called have it approved. If he doesn't put it, you can't purchase. Can't purchase. Please do needful. That's it. If you don't have this, you can't do the needful. No, can't do anything. What the appellant says, no, can't do anything.
Yes.
And then and at the bottom of page 507, we have it that court starts rebuking the appellant, says, we don't play with words. Listen well, we're not going to lose time. Issue is quite simple. All that you are being asked is what we call engineering. I don't know if you call it technique or not. Is the approval of engineering needed before purchasing the spare part? The appellant says yes.
Right.
So, and page 491, the last one, page 491, bottom page, last question. Do you have the right to launch a quotation if the engineering department does not make the request? This is a very clear question. The appellant says, no, I do not have the right. So this is very clear, and this testimony, this concession made by the appellant is, of course, to be found in the testimony of Mr. Modi as well, and that of Mr. Bagherati. Well, coming back to what your Lordship just asked me with regard to the sanction, we must not forget that he was also sanctioned in the past, and this has been proved in the course of the trial.
Yes.
So this is for the admissibility of the evidence of Mr. Bagherati. And with regard now to the facts, with the challenge to the facts, concurrent findings of facts by the inferior courts, which is being made here before the board. Of course, such a challenge should not be entertained by the board, as previous decisions have so stated. But in the event that my learned friend has addressed the board upon them, I shall reply to them. First of all, the challenge to the facts is to be found in paragraph 55 of the appellant's statement of case. Now, paragraph 55A alleges that
Yes.
the judge fell into serious error and contradicted himself in holding that Mr. Rajkumar's evidence undermined the appellant's case, when in fact it supported it. Well, first of all, as we have seen, the appellant has himself conceded that the prior approval of the head of engineering department was needed before the launch of that procedure, and this was confirmed by Mr. Rajkumar himself at page 540 and by Mr. Bagherati. Now, the testimony of Mr. Modi, as well as that of Mr. Rajkumar, coupled with the document P, show that in fact the judge was correct in holding that the evidence of Mr. Rajkumar fully supported the version given by the respondent. Mr. Modi himself testified that he had never seen any approval or request from the head of engineering department in the course of his investigation, and this is to be found at page 207. Mr. Rajkumar stated categorically that he had never given any instructions to buy the spare parts, and this is to be found at page 539.
Is there any dispute about this, really? Is there any dispute about this? No. No.
And the reliance of the appellant upon document P to show that such authorization had been given is incorrect. Document P, the first page of document P, bears the words and signature written by Mr. Rajkumar, and please do needful. And it is only when he writes these please do needful, as we have seen, that then the procedure can be launched. Yeah. But on that first page, there is absolutely, in the list, there is absolutely nothing with regard to 9 main shafts. Therefore, this particular first page does not assist the appellant. When we turn to the verso of the page, then we find that Mr. Rajkumar has not signed this page. This sheet bears the handwriting of the appellant himself, who took down notes following a conversation between him and Mr. Rajkumar. There is therefore no specific instruction with the words do needful to proceed with any purchase with regard to the list covered by the second page. But in any event, the second page does not at all refer to 9 main shafts again. So document P, as the judge rightly said, does not assist the appellant when he says that his launching of the IQ procedure was covered by an authorization or request from Mr. Rajkumar and relied upon document P. 55B says the judge fell into serious error in accepting Mr. Modi's evidence that the IQ procedure was only to be used for off-road buses. But Mr. Modi made it clear that this procedure could only be used or resorted to when buses had broken down and were waiting in the garage for repairs. And this is to be found at page 196. So he says, second question, so the spare parts were purchased by the procedure known as immediate quotation? Yes, there was an authority known as immediate quotation. And when is this procedure used? Prescribed NTC procedures say this type of authority is used only for buses for immediate use, for buses which are off-road. Sorry, can you repeat what immediate use for? For buses which are off-road, meaning they are in the, well, this is in the garage.
Not the guarantee.
Yeah.
Yeah. Right. Well, I think Your point is that there was certainly material on which the judge could properly come to the conclusion that this procedure should only be used for buses which were incapacitated.
Yeah, absolutely.
Yep, right. Well, let's move on.
And of course, Mr. Modi also explained that there were other conditions for the launching of this procedure, namely prior approval or request of the HED, and that there should be no other tender already alive, or that, and third and finally, that it was not applicable to slow-moving parts such as the main shaft. Now, paragraph 55C, this is a new challenge which was not made before the lower court. And D, where it is said that it was wrong in principle to rely on the fact that no main shafts were actually required. But this is clear from the evidence that no main shaft was required until June 2004. So there was a tender, what we call a normal tender, not an immediate one, which had been awarded to Mr. Kasamali in January 2004. In fact, on the 26th of January 2004, when the memorandum was sent to the appellant informing him of that tender. And the appellant had no valid reason to issue purchase orders on the 23rd of February. He knew as from the 26th of January of the tender concerning Kasamali. But then he went on to issue purchase orders on the 23rd of February for the purchase of 4 units, and on the 2nd of April 2004 for 5 more units. Eventually, 1 unit was needed on the 22nd of June 2004, and none of the units purchased on the immediate quotation procedure was used. There was consequently, my lords, no urgency to buy through this procedure in February 2004, insofar as, in the meantime, Kasamali had already provided 1 main shaft on the 6th of May 2004.
Yes.
And we also have the evidence from the bin card, which is document N at page 382, which provides, in fact, the answer to paragraph 55E, that in the past, only 1 main shaft had been bought by the corporation, and once it was used, another one was then bought if needed, and that went on for during the previous 2 years. So it was what Mr. Modi called a slow-moving item, and the appellant knew about it and had no reason to go and purchase 9 main shafts at 3 times the price, which Mr. Kasamali had quoted in the normal tender.
Right.
Well, so that is my answer to all the facts, to the challenge to the facts which had been found proved by the judge and endorsed by the Court of Civil Appeal. Now, new points have been raised. It concerns the delay, and well, the point of delay, in fact, has never been raised in the Court of Civil Appeal. It was mentioned by appellant's counsel in his skeleton arguments, but he never addressed the court upon it. He never mentioned it.
Well, in fairness to Mr. Rissogill, he raises it in a limited context. He says that if there is doubt to be cast on the findings of the trial judge that the question of delay comes into the picture because the dubiety that should attend the findings that made by him may be explained, at least in part, by the elapse of time from the trial and the delivery of the judgment.
If it is proved that that the findings of fact are unreasonable or perverse, then this may assist.
Right, right.
And we know
Your effective answer is that there's no reason to doubt the propriety of the findings that the judge has made.
absolutely.
And therefore the question of delay doesn't enter the equation at all.
Yes, that is so.
Right.
As Lord Mans stated in the case of Saint-Aubin and Despéville, 2011, UKPC 42, at paragraph 14, said, delay by itself is not a cause for setting aside a judgment.
Yeah.
Before
Well, I don't think Mr. Risso-Gill argues that it is.
Before disturbing it, of course, the court must see whether delay was such as that it impaired the judge's ability to reach a fair conclusion.
Right.
So, of course, the judgment has to be looked into. Yeah.
Right.
So I think I've done with this, with all the issues and the facts.
Thank you very much indeed, Mr. Ithia. Thank you. Now, Mr. Risso-Gill.
May I? My Lord, dealing with this time the facts first. On the first point in relation to Mr. Raj Kumar, we would emphasise firstly the dual purpose of document P. I tried to bring that out when I showed the board document.
Yes.
The first side deals with off-road. The second side, with the notes dictated by Mr. Raj Kumar, we don't suggest does deal with off-road, but, and it plainly doesn't, it deals with Mr. Raj Kumar's attempt to anticipate. Secondly, it is clear in our submission from the evidence I showed you from Mr. Raj Kumar earlier what he expected the effect of document P to be on Mr. Gunesh. He expected it to be, and my Lord may remember the phrases, to effect procurement, to obtain spares. He didn't think there was any more needed than document P. That is the request on which Mr. Gunesh, rightly in our submission, relied. It's suggested by my learned friend that Mr. Gunesh accepted that he needed a special approval from the head of engineering, and the respondent says such approval was not forthcoming. I've dealt with whether it was forthcoming or not, but in terms of what Mr. Gunesh accepted or not, and without taking your lordships back to the passages that have been shown you already, but by reference to them, on page 491, our submission is that Mr. Gunesh is simply accepting there that he needed a request, and that is the very word that is used in that passage, request from engineering. On page 507, on the first part of that page, Mr. Gunesh is dealing with the head of engineering's responsibilities, and he firmly denies that any approval from him was required. But then in the second part of the page goes on to deal with stage 3 and what he accepts, which is the technical mechanical officer's approval, which is required at the end of the process when the purchase orders are put in. He does not accept there that there was a special approval from Mr. Kumar, which he needed, let alone which he didn't have. And coming to page 510, passages there in relation to the phrase, please do the needful. In our submission, all Mr. Gunesh is accepting there is that in respect of the off-road buses, the phrase, please do the needful was required. Again, this is about the dual purpose of that document. He did need please do the needful about the off-road buses, and there it was on the page that dealt with the off-road buses. That was then a properly endorsed request, but that didn't affect the second page of it. And your lordship, the board may remember the passage I took you to in Mr. Raj Kumar, where Mr. Ithier says that's another thing. And this is, again, the dual purpose of document P. So that's all I would wish to add on that first point about Mr. Rajkumar, with respect to Mr. Modi, I didn't show you the passage of cross-examination at page 207, where he refers in support of his alleged restriction to the procedure to NTC E9 1995, but I would simply, if I may, remind the board that the content of that document, insofar as relevant, is at paragraph 8 of the Statement of Facts and Issues, and it says nothing about a restriction to off-road buses. As far as point D and the Casamali live tender is concerned, and the June requirement, we make the point there about hindsight. Only with the benefit of hindsight was it possible to see that Mr. Rajkumar's fears had not substantiated themselves. And secondly, as far as Mr. Casamali is concerned in particular, the entire failure or inability of Casamali to supply main shafts was something that the learned judge entirely overlooked in our submission. And I showed you, I'm afraid at breakneck speed, those passages of the learned judge responding to the submissions, but if I may draw the board's attention to those again, perhaps with a little more leisure to look over those, I hope that my submission will be borne out by a closer examination of those passages. That my lady.
Just encapsulate the submission again.
Yes, that there, in those passages of the submissions of the appellant on Casamali's inability to supply, the learned judge was looking firmly at what the appellant couldn't prove rather than on what the NTC could prove, and that he showed considerable reluctance to accept the point that Mr. Casamali couldn't supply any main shafts, and that finds itself illustrated in the way in which that point doesn't appear in the judgment. My lady, that's in a nutshell that point. But very briefly, on the question of the burden of proof, if I may, if the real point here is whether or not whatever language was used, the learned judge held the respondent to the right burden, we have two answers. Firstly, that is not how he was read to have approached the matter by the Court of Appeal, and indeed not by the respondent. And secondly, the word evidential burden does matter. And it matters for the reasons I gave the board earlier, that what that must mean, specifically focusing on an evidential burden, is that it places on the respondent only the burden to raise a case and places the burden on the employee to disprove misconduct. And that indeed is exactly the footing on which the learned judge approached the case we would submit. And that we would further submit that that's evident from the way he approached the facts. And I hope to have illustrated that as I've gone through the factual submissions.
Well, conventionally, in a criminal context, if a defendant raises an issue, let us say that a confession has been obtained by duress, the burden then shifts to the prosecution to prove beyond reasonable doubt that it wasn't. And you draw the analogy by saying that here all that the judge found was that it was only necessary for the employer to raise the issue, and then it was for the employee to prove a negative, really.
That would be the effect of the wording evidential burden, which seems to have been repeatedly used by both the respondent and indeed the Court of Civil Appeal. And that's the wording in which we would say there lies considerable mischief.
Yes,
and that's where we would ask the board to, depending on how it takes my submissions, to focus. But, my lord, yes, in short. And as far as the transcript is concerned, very briefly, in our submission, there's no doubt at all about the Northern Transport Principle, whether the court is substituting its opinion or not. If it is substituting its opinion differently from the way matters are approached in this country, if it is, it's doing so subject to the Northern Transport Principle. And secondly, insofar as the question whether the point was taken, we rely firmly for that on the wording of the judgment of the learned judge and of the Court of Appeal, in which they specifically addressed the question whether the cases were consistent or not. And we say that is an answer as to whether the point was taken. Unless there's any particular matter with which I can further assist, those are my...
Thank you very much.
I shall sit.
Mr. Gill, we're very grateful to Council for their economical, if not breakneck, presentation of the case, which I think has been very fully ventilated. And we're also very grateful to those who, behind the scenes, so to speak, or who didn't have a speaking part, nevertheless contributed to the elucidation of the issues that we will have to consider. The Board will take time to consider their judgment, and the Court is now adjourned.